This is your girl Black Onyx tuning in from Tucson, Arizona. Good evening, good evening, good evening. This is your girl Black Onyx tuning in from Tucson, Arizona. We're going to get into some things today and it's going to call Break the Corruption Change. We're going to say break the corruption change, corruption of the justice system. This is the case with Eric Smith versus the state of South Carolina. Black Honest Creation was developed and CEO owned by Shanella Burgess. Black Onyx is corruption versus the justice system. We're going to get into that today. Corruption versus the justice system. Let's get into this case of Eric Smith versus the state of South Carolina. Now, what we're going to talk about, guys, we're going to talk about this case. We're going to actually talk about this case, and what we're going to do, we're going to talk about this case, and we're going to break everything down. The first thing we want to talk about, we want to talk about the lie. The lie. Let's talk about the lie. The lie was, according to the investigator, the lie was the deal was over marijuana. The lie from one of the witnesses was we came to purchase buy marijuana from buyer one, Jed Coleman. This is the first connected lie, okay? The lie. Let's talk about what the detectives found at the scene. Let's talk about the vision. What did you saw when you was at this scene? The vision were they saw drugs, they saw fentanyl, they saw pills, they saw fentanyl at this scene. They did not see what they were told or heard, which was the lie. They saw the drugs fentanyl at the scene, which was what they retrieved from the scene of the crime. Now, what we want to do, we want to talk about the misinformation. When we say misinformation, what did the detectives or the officers or anybody relate to the public about this information? What did they relate? They relayed that they had a victim that was shot in the face. They relayed that they had a victim that was shot in the face. That's the information that was relayed from the sheriff department, from the police department, and the investigator. Now, at this scene, this is what we're going to do. We're going to go to what the detective knew at the time at the scene. The detective knew it wasn't a marijuana deal. The reason why the detective investigator knew it wasn't a marijuana deal, because they found the pills. So when the witnesses told them that they came to buy marijuana, they should have known right then that, okay, they didn't come to buy marijuana because we find drugs on the ground, okay? Now, ask yourself as a detective, if someone came to you and said they came to purchase drugs, that person is to be set aside, because at this point, you are agreeing that you committed a crime, correct? That's a charge. You are agreeing that you came to buy drugs. This is what your witnesses told you. Okay, that's one thing the detective knew. So that's one thing that the sheriff department knew. Okay. Now the detective knew it was fentanyl at the scene. Their own was hospitalized by the same drug, by the touch. So what the detective knew? They knew it wasn't marijuana. They knew it wasn't Xanax because they know by the touch of this drug, their own investigator went to the hospital. So they know that this drug was absolutely fentanyl. Even Sheriff Carter Weaver reported in the newspaper that the dispatcher told him it was fentanyl, okay? So at this point, they knew it wasn't marijuana. They had a witness who was there who admitted to coming to purchase drugs. Then they knew it was fentanyl because their own was hospitalized, okay? The detective knew the victim was the sheriff's son. Let's get that clear. Now, if you are a detective or a police officer, everyone knows fentanyl carries 20 to 99 years. Minimum 20 years for the sale and distribution of fentanyl. Minimum 20 years, okay? Now, let's see what the detective failed to do. They failed to charge anyone for drugs at the scene. Even though they had a witness that came to them and said, we came to purchase marijuana. Even though he said he came to purchase marijuana, that was a person who knew who the suspect were, who knew they came to purchase from, who admitted to coming to do a crime, which is buy the sale of this marijuana. But at this time, he wasn't charged for buying any drugs. Now, what did the detective do after this? They misinformed the people that the victim was shot in the face. The victim was not shot in the face. Let's get this clear, people. The victim was not shot in the face. The victim was not shot in the face. The victim was hit by a bullet that actually hit the co-defendant hand. From the co-defendant hand, went and hit the arm of the victim. From the arm of the victim, the bullet went through the bullet went through the co-defendant's hand, then the victim's arm, then the victim's jaw. So he was not shot in the face. Let's make that clear. And so what we're going to talk about here, we're going to talk about everything that these officers knew at the time. We're going to talk about the investigation. We're going to talk about everything that's transpired at this scene. Now, at this scene, they see Josh Miller at this scene on camera. They see Josh Miller. The shot was not captured on scene. That's one. That was not captured. But after the shooting, you can see Josh Miller running behind the store. Now, what purpose it is to run behind a store instead of in the store if you say you are running for help? You are running from the gas station, from the gas pump, to around the back of the store, then back up to the front of the store to run into the store to get help. Now, if I'm shot, and I know I'm shot, I'm going to run directly in that store to the first phone I can get, 911 call me. But because he ran behind this store, he said in court that he ran to the trailers, but the abandoned trailers behind the store. What is the purpose to running to the trailers to behind the store to get help when you have a phone and clerks inside of the store and other cars there at the store purchasing at the store? Why didn't you run inside of the store for help? Now that's the number one key right there, because guess what? They found pills behind the store as well. So the purpose of him running behind the store was to get rid of whatever else he had left. Then come back around, because like he said, he ran to the trailers, right? He said he ran to the trailers in court. He said he ran to the trailers trying to get help. Now, the detectives, they only caution tape off the back of the store. They didn't caution tape off back to the trailers, okay? So Josh Miller knew where he stashed the rest of his drugs at, so he can go back to get it. But the detectives did not put the caution tape to the abandoned trailers where he said he ran. They only put it to the edge of the back of the store. Okay, now let's get this clear. Now, let's talk about the victims in this case. We're going to talk about the victims and the co-defendants. Okay, as we were going through court, the victim, the dealer, which is Josh Miller, who is a well-known homemade fentanyl dealer for the sheriff's son. He's the sheriff's son, but he's a well-known homemade fentanyl dealer, okay? He's a well-known homemade fentanyl dealer for the community of Georgetown, all right? Now, Josh Miller has a friend who's deceased. I don't like talking about deceased people, but he has a friend by the name of Corey who is deceased, who succumbed to an automobile accident. It's not nothing related to this, and we want to say rest in peace to Corey as well, because I don't like talking about dead people. It's not right. It's not fair. And people are still grieving the loss of their loved ones, so we don't want to bring him up too much into the situation. But the dealer, Josh Miller, has a friend by the name of Corey, okay? Buyer one, Jed Coleman, which is the friend of the dealer and the deceased who has died. He's a well-known weed dealer for the community. Everybody call him the weed man, you know. Okay. Now, let's start with these two. The dealer and buyer one, Jed Coleman, are friends. They know each other. Okay. The deceased and Jed Coleman has relationship because the deceased buys a lot of marijuana from Jed Coleman. Okay? Now, let's get that clear. Now, Mr. Coleman called the deceased wanting some fentanyl pills. The deceased had none. The deceased contacted his friend, who he knew had some, which was the dealer, Josh Miller. Okay? Now, the deceased, Corey, went to pick up Josh Miller so they can meet Jed Coleman, so they can sell the fentanyl pills to Jed Coleman. That's the plan. Now, let's put buyer by affiliation of buyer one, which is Janiyah Gamble. Janiyah Gamble is roadie with Jed Coleman. They've always been friends. They always hang out together. Everybody know Bonnie and Clyde. Okay. Janiyah Gamble is a well-known fentanyl dealer as well. She's a fentanyl dealer, but she sells a lot of things. But for the community, everybody knows she's a fentanyl dealer, okay? A pill dealer. Okay? Now, she is friend with Jed Coleman. Now, these two already know they're going to meet Corey and Josh at the store to buy fentanyl. They already know this. This is planned. Now, let's talk about the brother of buyer one, which is Jaquan Coleman. Jaquan Coleman knows nothing about this deal. He's just in the car riding, waiting to go see some girls at a party. He knows nothing about the deal that's set up in place on the way to the party. He knows nothing. He's clueless. Now, at this time, you guys got to realize these children are 16 and 17 years old. The brother and the brother friend. 16, 17. I think Mrs. Smith had turned 18. Just was turning 18 that week. And Jaquan was 17 at that time. Okay? Now, these two are sitting in the car because it's Mr. Smith's birthday. So Jaquan Coleman calls his friend, Mr. Smith, asks him, it's your birthday week. You want to go to this party with us to get up with some girls? Yes. So these two don't have a clue of what's going on with the dealers with the buyer one and buyer two. You know? They don't know what's going on with these two. They're just in the car ready to go see girls. The other guys, they already gone on down the road. But they haven't pulled off yet because these two are still waiting on the dealer and Mr. Corey to pull up. But they don't know what's going on in this car, okay? That's the situation we have here. Now, let's talk about what happened at this store. Okay, let's talk about the court. Let's talk about what happened at the store. Okay? The dealer, Josh Miller, came with Corey in Corey's car at the store. Okay? Came in Corey's car at the store to sell, not buy marijuana, to sell fentanyl. Okay? Now, according to Mr. Miller, buyer by affiliation, which is Janiyah Gamble, thought the fentanyl pills were fake. So, now, everybody know Mr. Miller is a well-known homemade fentanyl dealer. So to Janiyah Gamble, to someone who knows what fentanyl looks like, yes, homemade fentanyl is going to look different to you because you're so used to the real deal, not the homemade one. So yes, she did thought it was fake. Because if you homemaking something versus having the real deal, homemade is triple time worse than the homemade. Homemade is triple time worse than the regular. Because now you're adding stuff on top of the regular. Okay? So yes, it didn't look fake to her. So Ms. Gamble decides to take the pills, but they went to purchase 42 pills. 42 pills. They went to purchase 42 pills. Now, Ms. Gamble snatches the pills from the dealer and decides she wants to jump out the back seat of the car. Ms. Gamble and Jed Coleman got into the back seat of Corey and the dealer car. When the pills was handed over to Ms. Gamble, she decides to jump out the car with the pills in hand. Okay? Jaquan Coleman, Eric Smith is sitting in the car waiting to go to the party. They've been drinking all day. They're getting ready to be right for this party. Now, Janiyah Gamble decides to run to the car with the dealer's pills, fentanyl, frantically. Dealer en route behind her. So when she jumped into the car, dealer jumps through the window. Now, the dealer jumps through the window, even though the dealer said that he got his pills back from her in the car. The dealer jumps through the window, chest and window. This is why he had the scar in the middle of his chest in court. This is why they couldn't figure out why the scar was in the middle of his chest. They keep talking about the scar in his chest, but you do the math. Jump through somebody's window. What's the first thing going to hit you? That window's going to hit you in your chest. This is why Mr. Miller had that big scar in his chest. Nobody put that there. He did that himself when he jumped through that car window. Okay? Now, just imagine brother and brother friends in the car, white man jumping through the window, choking out, which he was choking out Miss Janiyah Gamble. Eric Smith is in the front seat. Eric Smith had recently been shot. He's in the front seat. He saw Janiyah Gamble grabbing her gun, trying to point it at the dealer. But the dealer is overpowering Miss Gamble in the car, and the gun is pointing at Mr. Smith. Now, Mr. Smith, who has already been shot, has a barrel pointing at him inside of the car. So Mr. Smith decides to pick up the gun and shoot the gun itself so they can drop the gun. Now, he ended up shooting Janiyah Gamble in the hand, which the bullet traveled from Janiyah's hand, because her hand was on the gun. The bullet traveled from Janiyah's hand to the dealer's arm, through the dealer's arm, hitting the dealer in the jaw. This is how we got this whole case scenario. That is the scenario that happened, that came out in court, okay? This is what happened in court, you guys. Now, the state of South Carolina has a stand your ground law. If you feel that your life is in imminent danger, you feel that your safety is gone, you have the right to defend yourself. Mr. Smith, who has already been shot before, decides, I'm not getting shot again, and this gun is pointing at me, so I'm going to try to make you fools drop this gun. So I'm going to try and shoot in the middle of this gun so y'all both can drop this gun, because I don't know what's going on. Jaquan in the backseat, he don't know what's going on either. None of these fools on the rider side know what's going on, because this deal was it really was only between Jed Coleman, Corey, and Josh Miller. Jed Coleman decides to bring Janiyah Gamble along because he knows his friend is a fentanyl dealer. Jed Coleman is no fentanyl dealer. Jed Coleman always been a weed man. He's never a fentanyl dealer, but Janiyah Gamble is. His friend is. So I think that Jed Coleman just brought Janiyah along because I can get you some pills from these guys because they're my friends. I don't believe Jed Coleman knew Janiyah Gamble was going to snatch the pills and haul ass with him, because these are his friends. Okay? So at the end of the day, when you look at the scenario, let's talk about the scenario, because the reason why I want to talk about the scenario, because in the court, the solicitor said a hand of one is a hand of all. A hand of one is a hand of all. Now, I want to ask you guys something. If a hand of one is a hand of all, why did everybody got charges except the drug dealer? Ask yourself this question. Why did everyone got charged except the drug dealer of the fentanyl? Georgetown is the #1 out of 10 with the lowest population. Georgetown County is the #1 city on the list of 10 cities with fentanyl deaths. Now, you ask yourself this question. I want you guys to call and ask your solicitor the same question. Now, what do I call this? I'm going to tell you what I call this. This is the sheriff's son. These are black affiliations. This is white affiliation to the sheriff. Okay? This is the sheriff's son. Okay? At the end of the day, he got shot, but he didn't got shot maliciously. He didn't got shot to say, I'm going to shoot you to take your drugs. Okay? He got shot because nobody in the fucking car knew him and a white man jumping through a window, strangling somebody they knew, and they don't know what the fuck going on. So what I need you to do is drop this gun because I don't need to get shot. But if you let the solicitor of Georgetown County tell the story, oh, he was meant to be shot because they meant to take his drug. Now, I want to ask yourself this question. If ERYK Smith meant to shoot this dealer so Janiyah Gamble can get away to take the drugs, why wasn't Jaquan Coleman charged? Hands of one is the hands of all, right? Jaquan Coleman didn't get any charge. You know what the citizen said in court? Jaquan Coleman didn't have a clue. He didn't know what was going on. He just was a rider. So what the fuck was ERYK Smith? Tell me again, Miss Solicitor Alicia Richardson, what the hell was ERYK Smith? Because Jaquan got in his statements that he called ERYK Smith to go with him to a party for his birthday. So ERYK Smith didn't have a clue if he didn't have a clue. Only thing he know, he was inviting his friend to a party. Jaquan Coleman was a ride in that car, but Jaquan Coleman didn't have no charges. Now, you tell me, Mr. Solicitor, how ERYK Smith got conspiracy, attempted murder, and armed robbery charge. You tell me when ERYK Smith is a friend of Jaquan Coleman, not the friend of Jay Coleman. Now, make that make sense. Now, let's talk about this. This is nothing I want to talk about, right? The solicitor sat in court, said a hand of one is a hand of all. But I want y'all to think about something here. The reason why I want y'all to think about something here, because I'm telling you something. If the hands of one is a hand of all, right? All involved should have had charges. Because the hand of one is a hand of all, according to the solicitor, correct? Now, the reason why I want to talk about that is because there's something called vindictive prosecution. And when you talk about vindictive prosecution, the vindictive prosecution is you're protecting the real wrongdoer. Protection of the real wrongdoer. When you're protecting the real wrongdoer, you're failing to act within the bounds of ethics, which is Brady versus Maryland. In this case, the solicitor failed to act in the bounds of ethics. What she done was vindictive prosecution. The dealer received no time for the fentanyl. The dealer never was charged, period, for the fentanyl. Even though the investigator, Garrett, said that he turned it over to the narcotics team, the narcotics department, because he only investigate crime, and he turned the fentanyl over over to the narcotics team, the dealer was never charged. But I want y'all to think about this. How did Jed Coleman get a charge for robbing of the fentanyl and the dealer didn't get a charge for selling or distributing one? How did Janiyah Gamble get a charge for robbing the fentanyl, but the dealer didn't get a charge for the possession of it or the distribution of it? How did ERYK Smith get a charge for the robbing of the fentanyl and he didn't know nothing of the fentanyl? How did Jaquan Coleman get no charges for anything at all? And he was a rider in that car. But according to the solicitor, the hands of one is a hand of all. Now, this is called what I call vindictive prosecution. What you do with the vindictive prosecution, that is, you're protecting the real wrongdoer. Right here is vindictive prosecution. And what we're going to call vindictive prosecution is you're releasing the drug dealer, the number one leading drug in your county that is killing your county. And your county has the lowest population. You release this fentanyl dealer back onto the streets, correct? With no charge at all. But you charge everybody else involved other than Jaquan for robbing of fentanyl. You charge them each for the robbing of the fentanyl. So now, do that make sense? And I want to say this to all the Georgetown County residents. Does it make any goddamn sense? That don't make a hill of bean damn sense. Now we want to talk about victims. We want to talk about victims. Okay. The solicitor said Josh Miller was a victim because he was shot. Josh Miller was a known drug dealer. He was shot, but he wasn't shot because of selling drugs. He was shot because he jumped through a window of a car with people in the car with guns, and you're a white boy jumping through a black man window. That's how you got shot. You didn't get shot in the process of selling your drugs. You got shot when you jumped through a car window and nobody knows what the hell going on. That's how you got shot. Let's make that clear. Now, let's make this clear. I want to make this perfectly clear. The solicitor said the reason why she didn't give Josh any charges because he was the victim. Now, I want y'all to think about this. What was Janiyah Gamble then? Chopped liver? If the dealer was the victim, what was Janiyah Gamble? She got shot as well. The dealer was the victim. The sheriff's son was the victim because he got shot. But Janiyah Gamble got shot before the sheriff's son did. So why wasn't Janiyah Gamble a victim? Tell me why she wasn't a victim. Both of these fentanyl dealers was doing wrongdoing. She was buying it, he was selling it. Both of them got shot. Same scenario. So why did the dealer become a victim and the buyer didn't? That does not make sense to me. Does not make sense to me. How the dealer wasn't charged for fentanyl, but the buyer one, and the person who shot the drug dealer were charged with attempted murder, robbing of the fentanyl, and conspiracy. Ask yourself this question. This is Georgetown County Solicitor. So I want all of Georgetown, South Carolina people to listen to this and ask yourself all these questions. Ask yourself these questions. Because, see, this thing is going bigger than what we think it is. And see, they don't understand the vindictive prosecution behind this. They don't understand the exculpatory evidence that this lady failed to disclose in court. Okay? Now, we done established all of this. Even though she said the hands of one is the hand of all, you did vindictive prosecution because you protected the dealer, but you charged everybody else involved. You protected the dealer. You protected who you wanted to protect it. So that is called vindictive prosecution or malicious prosecution. That's what that is called. And that is grounds of disbarment. And not only that, let's talk about these charges. Let's not get too deep into this. Let's talk about the charges, y'all. Let's talk about these charges. Now, as we're sitting into court, we're sitting through court and we're like waiting on the next little ordeal to happen. And as we're sitting into court, the lawyer comes back and said, well, the solicitor already promised everybody involved no time but probation, but she wants to give ERYK Smith a 12-year plea for defending himself. Okay? The fentanyl dealer was initially not charged at all. So she promised the fentanyl dealer, if he come back, she promised him no charges, okay? Now, buyer one and buyer one, let's skip buyer two for a minute. Buyer one and the brother of buyer one sitting in the courtroom, in the courthouse, talking about their probation deal with the solicitor. So now the family of ERYK Smith is like, what the hell is going on? What the hell is going on? Because this boy just said, oh, she offered me a 5-year probation deal. She offered me a 2-year probation deal if ERYK Smith takes the plea deal for 12 years. Right? These are the deals that she offered. They come to find out she offered the same deal to Janiyah Gamble as well. Okay? If ERYK Smith takes the charges for 12 years. Now, let's talk about if he takes. Now, all these promises is made. ERYK Smith was locked up 939 days. 939 days. Not one time did the solicitor or the investigator ask ERYK Smith a question. 939 days. In court, she said he didn't reach out to us to tell us this part of the story. You had him locked up in your jailhouse for 939 days, and you did not ask him one question. When you locked up Jed Coleman, you questioned Jed Coleman. When you locked up Janiyah Gamble, you questioned Janiyah Gamble. When you got in contact with Josh Miller, you questioned Josh Miller. But when you got to ERYK Smith, Not one time did the solicitor or any investigator ask Eric Smith what happened. So, from what they gathered from the other parties, they charged Eric Smith for all the charges within the car without asking him what happened. Make that make sense. Make that make sense. So how did you do a proper investigation or a thorough investigation if you didn't ask what happened from Eric Smith? If you didn't get the story from what happened from Eric Smith? Now the solicitor got up into court, and this is what she said. She said, I don't know what Eric Smith is going to say, and I don't want him to say things that could not be, and I don't want the jury to hear what he had to say. Well, if you would have done your job as the solicitor and the investigator would have done his job as the investigator, you would have already had Eric Smith's statement of what had happened. This is the situation I'm talking about. When you don't get your evidence in order and you don't ask questions to know the outcome of the answers, and then you go and you press charges against people without clarity or of the evidence or investigation of thereof. This is failure of the justice system. This is illegal and unethical. You cannot promise anybody nothing. You cannot promise a criminal no time. That's unconstitutional and unethical on all parts. Now, this was brought out first before the judge, and the judge himself looked at the prosecutor solicitor. What do you mean, promise? And like Mr. Smith's lawyer said, she promised a whole lot. Now she's scrambling to try to figure out what did she promise, but she failed to realize she promised him all this stuff before she even talked to Eric Smith. She didn't know what Eric Smith done. She didn't know what Eric Smith done, said, or nothing in the car, because she never talked to Eric Smith to get his side of the story. She never asked a question, nor did the investigator. They never asked Eric Smith anything. But the investigator said he did when he talked to Josh, and Josh admitted to lying. He said Josh lied, and Josh lied on several occasions about the keep lying about marijuana when they already had the drugs. He's still lying. So even when these guys were going to court with the solicitor before this trial, the solicitor still was bringing marijuana up into these court cases when she already had evidence that it was fentanyl. But she still went to court because when Eric went to his preliminary hearing, they still had marijuana as the charge in the case. Now, by this time, you 2-3 years down the line when Eric Smith went up for preliminary, why are you still saying it was marijuana? Because, let me tell you why. This is the sheriff's son. We do not need him to have a fentanyl charge, because any charge with fentanyl carries minimum 20 years, maximum 99. So we cannot have it to be fentanyl. We're going to have to keep it as marijuana. So this daddy intentionally went to court on several occasions, at least 3 at the maximum occasions, still saying it was marijuana in a court of law. Because at this time, Charles Barr was Eric Smith's attorney. And she went to court with Charles Barr speaking a year later. She already knows it's fentanyl by now. A year later, she's still coming to court as marijuana. So that telling you right then, the solicitor was trying to push this case through as marijuana, knowing it wasn't. She knew it wasn't marijuana when she went up for the preliminary, but she still went before the judge and gave them false information, falsified information. She introduced false evidence into a preliminary hearing, knowing it was not marijuana. She knew it was fentanyl. So you did the crime the first preliminary hearing, because you didn't brought it to the court as fentanyl or even Xanax, as you said in the trial. You brought it forth to the judge as marijuana. And this is a year after court. This is the preliminary hearing of Eric Smith. This time she already knew, because by this time Sheriff Carter Weaver had already did a statement the next day on the news, stating that his officer was hospitalized because of the touching the collection of the drugs from the store. Everybody know touching Xanax is not sending your ass to the hospital. Everybody know you touch some fentanyl. Fentanyl is for cancer patients. severe pain medicine for cancer patients. You will be hospitalized by the touch. That shit can kill you. Everybody knows this. Now, the investigator was hospitalized, and Sheriff Carter Weaver got onto Gab News and Post and Courier and made statements about this said drug fentanyl. But the solicitor still brought it back to court because she was coming to trial now, and she knew it would have came out as pills. It wouldn't have came out as marijuana. Even though she went to a preliminary hearing still saying it was marijuana. She came to the trial, oh, it was Xanax. Now, let's talk about this trial thing here, right? Let's talk about this trial. She said, okay, Miss Janiyah Gamble told her girlfriend to clean the car out, take all the drugs out of the car, right? The police went to Janiyah Gamble's house, and they showed her the text that Janiyah Gamble texted her from the hospital and said, take everything out of the car, clean the car. Correct? Now, you went in Janiyah's trash can to get drugs out. You went and got drugs out Janiyah's trash can, right? You tested those drugs from Janiyah's trash can. You brought those to court. Now, let's say this. Let's say Janiyah had other pills. She's a known drug dealer. Let's say she had Xanax, and you tested Janiyah pill, but all the pill was on the ground at the store that you collected at that scene. But you went to Janiyah trash can to get the pills out of Janiyah trash can. Then you're going to come back and say, this is the drugs. So when the SLED agent got on the stand, they was like, this is the drugs from this case? Yes, no. She said, yes, this is the drugs from ERYK Smith, Jade Coleman, Janiyah Gamble. Yes, the SLED agent said. Now, when they went through all this toxicology report and everything, all said and done, cross-examination got up, correct? When the cross-examination came across, ERYK Smith lawyer asked the SLED agent one time, I need you to read whose report is this? Whose name is on top of this report? Because you're stating in a court of law that the evidence that the solicitor just gave you was the evidence for ERYK Smith, Jade Coleman, and Janiyah Gamble. Now, I need you to go back and read on top of this toxicology report what name and what report is this for. When the SLED agent looked on top of this report, she held her head down. She looked up and he said, I need you to say it louder. She said, Janiyah Gamble. So now how are you going to present evidence to the court as ERYK Smith evidence with Janiyah Gamble name on the top of a SLED report? It's not even the report from what you're talking about. That's what we call falsifying evidence in the courtroom. This is what we call introducing false evidence into a court of law. This is grounds of disbarment. You cannot introduce false evidence as evidence to a jury or a court of law or a judge as said evidence when you already knew the name on top of that report was not the report of which what situation you are talking about. That is what we call a blatant lie in the court of law. She should have been stopped. This trial should have been mishap. It should have been thrown out and dismissed because she's providing false evidence as evidence to a juror and to a judge. Okay? That's what we call false evidence. That's grounds for disbarment on any level of a court. Okay? Now, let's talk about the situation that was going on in the courtroom. Okay? Now, as we're talking, she keeps saying Xanax, Xanax, Xanax. Okay? Now it's time for her to bring the witnesses. Okay? The witnesses. Because let me tell you something. She knew if she would have brought Jade Coleman, Janiyah Gamble, and Jay Quant up the witnesses, they was going to testify it was fentanyl they was buying. So what the solicitor did, she dismissed She dismissed Jed Coleman, Janiyah Gamble, and Jaquan Coleman from testifying. So the lawyer got up and said, what are you talking about? I need to cross-examine them. So she was like, well, you should have subpoenaed them. Everybody knows, and I don't even understand how this judge don't know, but he went old as fart anyway. I don't even understand how he didn't know that you cannot subpoena state witnesses after they already called them as a state witness. You can cross-examine them, but you cannot subpoena them. It's always been a rule of law. Once the state calls somebody as their witnesses, you cannot call them as your witness. Because the state has already subpoenaed them to the same trial as their witnesses. You can cross-examine them in court. So what she done, she dismissed Jaquan Coleman, she dismissed Jed Coleman, and she dismissed Janiyah Gamble. She didn't want them to testify. You know why she didn't want them to testify? Because they would have had to testify on the amount of pills that they went to buy. They would have had to testify on what kind of pills they were going to buy. And this would incriminate Josh Miller in a court of law. So what she done, she withdraw them from testifying, okay? That's what she would. Now, when she done that, what did she do? She failed to act within the bound of ethics, unethical and unconstitutional conduct by a prosecutor. Because if you're going to prosecute somebody, they're going to have to come across your witnesses. And now, if you was not going to use those witnesses in the court of law, you should never subpoena them, because you know the defense team can't subpoena them. So when they went to subpoena the witnesses for the court case, they was already subpoenaed as witnesses for the state. So the defense team could not subpoena the prosecution team because they're already state witnesses. Now, what she done, she dismissed them in the middle of trial. She didn't call them in the middle of trial. What that sounds like to you? Unethical, unpractical, and going above and beyond the law as her own authority, not as the law. Because you cannot do that in a court of law. You subpoena them, they're supposed to be on that stand. That's a witness that needs to be cross-examined. But she knew if those witnesses got an understanding and had cross-examination, it would have incriminated her whole case. It would incriminate her whole case. Because like she said, a hand of one is a hand of all. Now, let's talk about this right here. Fentanyl carries 20 to 99 years for the distribution or selling. The sheriff's son received 0 time. No time, not even after hospitalization, not 4 years later at court. No time, 0. Now, I want you to ask yourself this question. Even though the fentanyl charge was not developed by the law, sheriff, solicitor, anybody, why did the accusers got charges for robbing the fentanyl? Why did the accuser got conspiracy of the fentanyl? Why did the accusers got robbery charges of the fentanyl? And the fucking dealer didn't get no charge for the fentanyl? I need you Georgetown County people to ask y'all solicitor this question. How the hell can you get charges for robbing fentanyl and the dealer don't get charges for having fentanyl? Make it make sense. The clueless individuals receive no time, which is the brother. That's a clueless individual. But the hands of one is the hands of all, but he didn't get no charges. He was in the car just like Eric Smith, a writer. Ask yourself, you got to ask yourself these questions. The friend of the brother received 20 years for defending himself because he shot the co-defendant in the hand, was traveled to the arm of the defendant, then to the defendant's jaw. Even though the doctor already said this in the court of law, they still say, oh, the accuser shot the defendant in the face. But you exclude that the bullet went from the co-defendant's hand to the accuser's arm, then to the accuser's jaw. This is what the solicitor planted to the jury. She didn't even tell the jury that the co-defendant was shot in the hand. She didn't even tell the jury it was only one bullet. One bullet that shot 3 places, through the hand, through the arm, through the jaw. She just said the accuser shot Josh Miller in the face. Janiyah Gamble was chopped liver, an animal on the street. She was not even a victim, even though she was shot as well. There was only one victim, and that was the sheriff's son, the dealer. Let me tell y'all something. There is no victim in a drug deal gone bad. All are criminals when you deal in drugs. There is no victim in a drug deal gone bad. And you can tell Josh Miller ass didn't want him to be there. Josh ass didn't want to be in no damn courtroom. He lied so bad under oath he was lying. This drug is not mine. This drug did not belong to me. Here goes the solicitor. They took the property of the defendant. Here goes the defendant. That drug was not mine. It did not belong to me. Here goes the solicitor. They took his property. He went back in there to get his property. Here goes Josh Miller on the stand. Those drugs was not mine. So, Miss Solicitor, you're telling the courts that the drug was your defendant, while the defendant is telling the court the drug isn't his. Now, you keep telling the courts the defendant went to get his property. The defendant keeps saying that was not his property. Constantly, he said over and over in court, the drug was not his. It was Corey's. It was not mine. It was Corey's. He kept saying it religiously over and over. The solicitor keeps saying the defendant Josh Miller went to get his property. Now, you know why the solicitor kept saying that the defendant Josh Miller went to get his property? Because she knows that Josh Miller didn't have that right to go through nobody called women to get something that belongs to somebody else. So she has to keep saying it was Josh Miller's drugs. That's the only way she could have protected him. Josh Miller didn't understand this because he's young. So he kept saying in court, it's not my drug. That was not my drug. He kept saying, this is not my drug. Every time he was asked, I don't know why y'all keep saying this is my drug. That's not my drug. The drug did not belong to me. It belonged to Corey. Mind you, Corey is dead. Corey can't speak. So he's protecting himself by saying it's not mine, it's not mine, it's not mine. Not knowing if you enter into somebody's vehicle to receive to retrieve something that is not yours, you are actually committing a crime. Because if that's not your property and you jumping through somebody's window to get somebody else's shit, it is not yours, you're committing a crime as well. The solicitor keep iterating. Hey, the victim went to get his property. He went to take back what belongs to him. Here goes the victim getting back on the stand. That did not belong to me. That did not belong to me. That belonged to Corey. However way you put it, the solicitor was painting a picture for the jury. The victim keeps saying it was not his drug. The solicitor keep embedded to the jury it was his drug. So when you giving false information, when this guy is giving a whole total different story, you understand? You can't say it's his if the damn victim is saying it's not his. You know by him keep saying it's not his, didn't give him the right to go in nobody killed car or jumping through nobody window to take nothing that did not belong to him. Because he would have had to get a charge. This is why the freaking solicitor keeps saying the victim went to get his property back. No, he didn't. He said it was not his. It was not his property. Now, this is the thing. There is no victim in a drug deal going bad, period. No victim in a drug deal. I don't feel sorry for no victim in no drug deal. None. But with this case, I feel like if that fucking fentanyl dealer walked, everybody involved should have walked. Everybody involved in this dealing should have walked just like the fentanyl dealer. Because if this dealer ain't getting no time for fentanyl, everybody involved with the charge of the fentanyl need to walk. You cannot allow a drug dealer of fentanyl to walk free, then charge the co-defendant of stealing fentanyl, and you didn't charge the drug dealer for the fentanyl. That's crazy. So what did they took? Drugs? You didn't even prove they took the drug. That's another thing. You didn't even prove what they took. You didn't prove nothing of what they took. But you charge all of them with robbery of the fentanyl, but didn't charge the dealer with fentanyl. Now, what do we call this? What do we call this? The dealer was never initially charged with selling or distribution of anything. The dealer was also promised. He was promised by the solicitor no time. Promised by the solicitor. One thing you cannot do in a state of law as a judge or lawyer or a solicitor is promise nobody no time. That's grounds of disbarment. You must be a write up for misconduct of office, illegal and unethical conduct by a prosecution. You cannot promise nobody nothing. And it was promised to him by the solicitor. This was brought up in court. The judge said, "What do you mean promise?" Because he knows a solicitor cannot promise nothing. She scrabbled and scrabbled and scrabbled and scrabbled, trying to figure out what she was going to say to this judge. And then the lawyer said she promised a whole lot. She promised all of them nothing. Only thing she wanted was for ERYK Smith to get 12 years, and she gave him a 12-year plea. And they were getting all this on depending on the 12-year plea. You know what this is called? This is a vindictive prosecution. Malicious, vindictive prosecution. Failure to act within the bounds of the law. Solicitor Alicia Richardson failed this system by protecting the wrongdoer. Right? Because let me tell you, when I say protection of the wrongdoer, when I say protection of the wrongdoer, none of this would occur if the fentanyl dealer didn't come to sell drugs. If the fentanyl dealer didn't come to the store to sell drugs, none of this would have occurred, right? If he didn't show up to sell the drugs, right? So when you go to court and you're doing everything to protect the fentanyl dealer, this is what we call vindictive prosecution. This is what we call vindictive prosecution. What you did, you failed the system by protecting the wrongdoer. You only had 3 wrongdoers in this case. That was the dealer, the buyer, and the initial buyer. 4, the deceased. But we don't talk about him at all because I don't like talking about dead people. He's dead and he can't defend himself. So the dealer, the buyer 1, and buyer 2, those are the only 3 victims of wrongdoing in this case, right? Now you tell me, how did the buyer 1 and buyer 2 got charged for the fentanyl, but the dealer didn't? But then she turned around and said, the seller, the buyer by affiliation, she stated, a hands of one is the hands of all, but the dealer was not charged. Make it make sense. This is what we call corruption of the justice system. This is what we call malicious and vindictive prosecution. This is what, let me tell you what else she done into this court, right? Let me tell you what else this solicitor done. When she done her closing argument, she said, ERYK Smith, he's a murderer. He's unsafe to be on the street. He should not be on the street. This is what we call expression of personal opinion. This is not acceptable in any court of law. You cannot give an expression of personal opinion towards a jury to reflect on ERYK Smith. But now she did all this, but she wouldn't let the lawyer tell the story that ERYK Smith has been shot previously, before this. So if you're looking down a barrel of a gun and you already been shot previously before this, shit, you back the fuck out. You don't give a damn who you shot, okay? You're just trying to save your damn life. Now, what she done, she painted ERYK Smith as a murderer. Now, I want you to ask your solicitor this. If you're in a court of law and you painted ERYK Smith as a murderer for protecting himself, what is Josh Smith? What is Josh Miller? What is Josh Miller? Fentanyl dealer. What is Josh Miller? Miss Solicitor Alicia Richardson. I need you to answer this question. What that makes Josh Miller? A fentanyl dealer. Georgetown County is the number 1 on the top 10 of fentanyl deaths. Josh Miller is a homemade fentanyl dealer in the county of Georgetown. Georgetown has the lowest population on the top 10, but the most deaths from fentanyl. But the solicitor Alicia Richardson, she called ERYK Smith a murderer for defending himself at a gun pointing at him while they're fighting over a fucking gun. Now, if ERYK Smith wanted to shoot to make Janiyah get away, why would he shoot Janiyah? Y'all make this make sense. Why would Janiyah got shot? That don't make sense. Like he said in court, hell, that gun was in my line of fire. That gun was pointing at me. Hell, I tried to shoot the hand that had the gun, and they both would have dropped it. This is why ERYK got a not guilty plea for conspiracy, a not guilty plea for robbery, and a not guilty plea for attempted murder. All three of these pleas that the charges that he had in court were not guilty. You know what this solicitor did? She went in court, come back with an ab hand charge. An ab hand charge. Assault and battery in a high aggravated nature. Now you ask yourself, in a stand your ground state, your life is in imminent danger. How is an ab hand charge admissible in court if the attempted murder wasn't? Now, this is the thing. What this lady did, let's talk about what she done in court. She lied to a judge. She lied to a jury. She introduced false evidence into a court of law for toxicology for Janiyah Gamble instead of this case. And what else she did? After this whole case is said and done, she done vindictive prosecution. She let the dealer of the fentanyl go free, but charged the 4 black parties for the fentanyl of robbery of the fentanyl. She failed the system. She failed to act within the bound of ethics, period. Now, Georgetown County Solicitor Alicia Richardson, check this out. Unconstitutional behavior. She actually did a BRADY violation in court, did gigolo. BRADY violation, that's what we call it. She did a malicious vindictive prosecution in the court of law. She failed to act within the bounds of ethics. She was illegal and unethical as a prosecutor in a court of law. Period. Now, you do not have the right as a solicitor, judge, or lawyer to promise. You cannot promise any criminals no time for a crime committed. You cannot promise no time for a crime committed. No time that she promised Mr. Miller. So what if he is the sheriff's son? This is unconstitutional, and it can be cause of disbarment. You don't have the right to be a solicitor and practice vindictive prosecution to protect the wrongdoer. You are failed to act within the bounds of ethics, illegal and unethical conduct by the prosecutor. BRADY versus Maryland. You did not have the right to withhold exculpatory evidence or provide false evidence to a court of law. This is grounds to be disbarred. You abuse your authority on all levels of the court. Making promises before questioning witnesses, making plea deals be based on the acceptance of someone else's guilt is unconstitutional and immoral, and on all levels of the court should be investigated. This is all grounds for misconduct of office and disbarment. This is what we call corruption of the justice system. This is what we call corruption, unethical conduct, misconduct of office, vindictive prosecution. She actually did all of this misconduct before a judge who in return asked her, what do you mean promise? This is the only time the judge got mad, because when she found out that she promised all these things, he wanted that explanation. He wanted to know, what did you promise? And why did you promise? But she couldn't even give the judge an actual answer. She overtalked, overstepped, and still didn't give the judge a complete answer on what and why did she promise. The jury come back deadlocked. Deadlocked. They couldn't even come to a decision on the ab hand. Deadlocked. The juror was deadlocked. They sent the juror back twice for the deadlock on the ab hand. Because this is a charge that you added in. This was not one of the 3 charges. All 3 charges were not guilty. She came back with an ab hand, and the jury came back deadlocked twice. And like the judge said, if you come back deadlock again, we're going to have to do it a mistrial. They came back deadlock on the ab hand charge. This is something the solicitor add in. while she's protection of the wrongdoer. And this is what we call vindictive prosecution. We do not need to have solicitors like this in office. We do not need to have dirty skis bags like this in office. We do not, if you're not going to practice justice as justice, and if you're not going to do justice for all, you can't do justice for some. You can't pick and choose who to give justice to. That's not the law. The law is not pick and choose who I'm going to give justice to. Just because you are a party of a sheriff. That does not give you the right to change the system to give justice to some and injustice to all, to the rest. This is what we call malicious vindictive prosecution. This is what we call Brady versus Maryland, the Brady violation. She done it. She needs to be disbarred. She needs to be disbanded, and she needs to be written up for misconduct of office. Period. This is why people of color do not like law enforcement, do not like lawyers, judges, none of these things, because these are the type of immoral things that they do in court, and the lies, the introducing of false evidence, the vindictive prosecution, protecting the wrongdoer just because he's a sheriff's son. You don't protect nobody when you got a law or a job to do. You don't protect no one. If you set hands on one of the hands of all, then all should have been charged accordingly to the law. And the reason why Josh Miller didn't get a charge, because she know fentanyl carried 20 to 99 years. Josh Miller charge would have been minimum 20 years. Minimum 20 years. But yet Eric Smith get 20 years for defending himself, defending his life with a gun pointing at him that Josh Miller and Janiyah Gamble was fighting over. That could have shot him. But then he got an ab-hand charge for just firing a firearm that saved his fucking life. But now let's say this. Eric Smith would have got shot by this gun that Josh Miller had. I promise you, for macaroni and cheese, Josh Miller wouldn't get a charge. He still would have had no time right now. And people don't understand this is why people of color be petitioning and protesting the justice system. The justice system is just for some. It's not for us. It's just. It's not just us. It's just us when it comes to the black people of color. But the justice system only justice for them. It's just us when it comes to people of color. And this is why we don't need biased people like this into office. You giving your personal opinion, you being biased, and you're doing vindictive prosecution, protecting somebody who is the sheriff's son, and you giving false, misleading evidence to the juror. And this is why she needs to be written up for misconduct and disbarred. This is unacceptable in any court. And let's talk about this week. Like, y'all, I'm going to tell y'all. Let's talk about this week, the week of the 16th, as we were sitting there in court. As we're sitting there now, we have a young guy by the name of Justin. Justin hides a kite. Justin, I swear to God, that boy ain't been on meth. He been on something lilac, cash, what the hell he been on. Because he was high as a kite in that court. I said, oh my God, this boy, he couldn't stop walking. He eye wandering everywhere. He eye glassy, watery. He ready to go. Now, Justin had a strong armed robbery charge, breaking and entering twice to charge, possession of drug twice to charge, assault and battery, prior conviction notated. And let me tell you what Justin's results was as he come out that courtroom bragging. 5 years probation. 5 years probation. Okay? Justin got 5 years probation. For all that, he got 5 years probation. Probation. The next case that came out 15 years suspended sentence. 5 years probation drug charge. That's the second case that came. The third case that came out was armed robbery, assault, possession, theft. 5 years probation. All these people came out with 5 years probation. These people literally came out of this courtroom bragging about how little time they got and received and probation. But yet, I want y'all to think about this. Think about this. Think about what color these people were that came out. All these charges, robbery, breaking and entering, assault and battery, possession, theft, they came out, all this, 5 years probation. Right? Tell me what color these people were. I don't even have to tell you that. Now, yet, our black men sentenced to the maximum for the same crime that Justin did. The same crime for The second case and the third case. But they all came out with 12-year plea. 12 years. Oh, no, we gave you a plea for 12 years. For the same exact crimes. Same exact crime. These people had prior charges and come out with 5 years probation. But our black men went in there with no record, coming out with 12-year plea deals, 12-year sentences. Now, I know why Miss Alicia Richardson's staff and the co-workers and the police officers don't like her. Now I see why they talk so much about her behavior in office. I understand now. Because all these charges these people up here got for the week of May 16th, all of them had a 5-year probation. And just for conspiracy and a robbery charge of the fentanyl, they got 12 years. Can you ask me again? What was the race of all these people that got off like that? Can you ask me what was the race of these people on May the 16th through the 25th? Conspiracy and robbery charge. They still charged Janiyah 12 years. But Justin, strong arm robbery, breaking, entering, possession of drug, assault, and bad, same prior convictions. Oh, Justin got 5 years probation. Make it make sense. Make it damn make sense. Like I said, the judge